Hello and welcome to Ikike Digest, the learning space on Home FTV. I am Kome Ojomo. On Ikike Digest, we aim to continuously bring to light environmental issues as it affects communities and policies and our food system. We also highlight policies that do not speak well to the people and draw our attention to our listeners. In today's edition, we will be examining political roots of environmental harm. The political roots of environmental harm are complex and multifaceted and involves various levels of governance, economic systems, and structure. The lack of effective regulations and enforcement, coupled with inadequate environmental policies and laws, empowers fossil fuel lobbyists. The key players influenced disinformation, lack of environmental education and awareness, and impact vulnerable populations. In today's edition, we will expose how environmental regulations can strengthen communities, promote awareness, and empower marginalized communities to transition to renewable energies and sustainable economy. We have Barrister Iniruo in the studio to better explain environmental harms through political roots. Iniruo is a Nigerian lawyer, environmentalist, and advocate for human rights, particularly in the Niger Delta region of Nigeria, and has served as the Commissioner for Environment in Bayelsa State, one of Nigeria's oil-producing states. During his tenure, he worked on policies to mitigate the adverse effects of oil exploration, promoting sustainable development and safeguarding local community rights. Barrister Wills is known for his expertise in environmental law and public policy and his efforts to address the environmental degradation caused by oil extraction and exploration in the Niger Delta. His experience growing up in the region influenced his passion for environmental advocacy. He pursued a career in law, focusing on environmental justice and governance. Barrister Wills is a vocal advocate for rights of the people in the Niger Delta, particularly regarding environmental justice. His work has earned him recognition as one of Nigerians' leading voice in the fight for environmental justice. You're welcome, sir.
Thank you.
We're looking at political roots of environmental harm. So how would you say that political system and institutions contribute to environmental degradation?
Okay, thank you. In your preamble, you described the theme of the political roots of environmental degradation as a complex issue. And I think you're quite correct. It's complex, but depending on how you look at it, it's also pretty straightforward. In the sense that there are two angles from which I see political rootedness of our environmental problems. One is historical, but with grave, present, and continual consequences. The other is contemporaneous, and I'll explain briefly. So first, historically, the colonial background of Nigeria, the colonial enterprise, the objective of it was simply to extract resources from the colony. It wasn't about developing the colony or developing the people or advancing them. There was just a single objective, And at the time of independence, all right, there was no restructuring or redesigning the country according to the desires and aspirations of the people of Nigeria. So that objective, that colonial objective of extraction of resources, of economic benefits, remain the root, the underlying basis of the design of the Nigerian state, the structure of the Nigerian state. So everything about Nigeria's institutions was meant to serve that purpose, and even though the realities, global realities, at the time demanded that independence, take place. But what happened was that the Nigerian state, as designed for those colonial objectives, was left as it is, and handed over to an elite, a local elite, that just continue to run with that objective. Now, that meant that the local elite would benefit, but the economic flows, the financial flows that were already on, which ultimately benefited the colonial masters and their economies, remained as well. So a Shell, which started as Shell Darcy also and had its initial license over the entire country for, I think in the 30s or so, Shell and the other companies, Mobil and so on, continued to produce. They had their licenses and leases, all right? And the interests ultimately were to benefit the owners of those companies. It's only now we're starting to do divestment to Nigerian companies. And even that is being done in a very questionable manner. So what I'm saying is that at the time of independence, the Nigerian state, designed for purposes of that colonial enterprise, was simply handed over without any fundamental restructuring or redesigning, or my preferred term, having thought of these issues carefully for a long time, really is repurposing of Nigeria. There was no repurposing of the Nigerian state as was created in between 1900 and 1914. There was no repurposing as of 1960 until date, and it was just handed over, which means the Nigerian state and the various activities, economic activities and institutions, within the Nigerian state were built to serve the purposes of, that's the extractive purposes of the original colonial masters and their various constituents in their home countries, and the local elite that took over from it. And that's what has remained till now. That meant that the interest of the people, the interest of communities, the interest of the environment never ranked. Yes, there will be laws and policies, but it's just to tick the box that we've made laws. Even the legal systems, the lawmaking systems were not set up for purposes of ensuring that the right thing is done. So it meant that profit maximization, was the motive and remains the motive. Yes. And there are no institutions built to check the excesses, the recklessness of the operators. And here we are now with Nigeria as the most petroleum polluted country in the world, and the Niger Delta as, of course, the epicenter.
Yeah, yes. So can we say it's because of this control that the PIA was initiated?
Well, I don't know if I want to put it that way, but the PIA I would describe as a red herring. There are a lot of good things about the PIA, we have to admit, especially in terms of the institutional reorganizing of the industry, Whereas before now, you just had the Federal Ministry of Petroleum, dishing out regulations, enforcing, doing the licensing and all that, which is anachronistic, What really should have happened is that you have policy domiciled in the Federal Ministry, then you have regulation, licensing and regulation domiciled in an independent regulatory body. These are reforms that we have seen in the electricity sector, we've seen in telecoms, and the petroleum sector only came in a bit late. So to that extent, and also in other areas, the Petroleum Industry Act, it has introduced reforms that are beneficial to some extent, but there are many ways, and we can't exhaust them in this short conversation. There are many ways in which the Petroleum Industry Act came late and is presenting too little, not just in relation to communities and the environment, but also in relation to the overall national economic interest and in relation to global realities and imperatives. For example, the just transition, the energy transition we're seeing all over the world, even though the pace of it may be slow and sometimes may even appear to stagnate because of geopolitical events like the Ukraine-Russia war and so on. So the PIA, how can a law, an industry consolidation and reform law that came into being so recently, not have any concrete energy transition provisions? So there's very little ambition within the PIA. But let's relate it to communities and the environment. That is the area in which the PIA is really a disgrace. The Petroleum Industry Act is really a disgrace and a reflection of what sometimes I'm tempted to call national stupidity index. Because how do you, now even before the PIA, you had the provisions in the Oil Pipelines Act, that penalized or dispossessed communities of their rights once there appeared to be a suggestion that a spill or some damage event was caused by a third party. All right? I mean, these are innocent, impecunious communities. And you bring facilities for your own purposes to their territory. And then when something goes wrong, you don't take adequate precautions to ensure that those things do not cause any damage to their environment. Worldwide, especially within the context of the common law that we inherited from our colonial masters, Britain, the principle is strict liability. If you bring something that is a non-natural user of the land or of the environment, you have strict liability for anything happens. No fault. Even if it is not your fault, the fact that you brought it there. So if you set up a zoo in my territory, you have strict liability to ensure that the lions don't run out of their cages and start devouring people. It doesn't matter that you did not go to open the cage yourself. Even if someone else came to open it. The question is, why didn't you take sufficient precautions to ensure that that doesn't happen? Because the existence, the location of that facility alone presents an inherent danger and hazard to the natives, to the residents of the area. So there was that provision that accepted that common law principle in Nigeria. I don't know how many other countries would make such an exception, that if pipelines are damaged by third parties, then there will be no compensation for communities. That is an infraction. In fact, it's unconstitutional because it's an infraction of the people's constitutional rights to own and enjoy property. So if I have property, land is property. The environment is property. There are property rights in the environment, which God gave to us. They are inherent. It's not the Constitution that gave us our fundamental rights. We need to make, let me make this clear. It's not the Constitution that gave us our fundamental rights. Our fundamental rights, human rights, inhere in us. The Constitution is merely a certificate that you actually have these rights. All right? So you cannot, those are inalienable rights. So if you now introduce an activity that affects my enjoyment of those rights, property rights, right to life, good health, and so on, it means that it's unconstitutional. So, but somehow, because of perhaps our very limited practice of law, let me say, in Nigeria, those provisions have not been adequately challenged. And they continue to be in operation until the PIA. Now, you would expect that the PIA would have been more civilized. The drafters of the PIA would have shown more civilization, that we've moved from 50 years ago to a new mindset. Unfortunately, the Petroleum Industry Act even doubled down on what was already an egregious error in the Oil Pipelines Act. So the Petroleum Industry Act not only retains that provision, but goes further to say that where there is damage, because you know that now the PIA has introduced the Host Community Trust Fund, which on the surface is a good thing, all right? Let's not go into the details of it because we can go on and on. I think that the communities were hugely shortchanged, even in how the Host Community Fund has been structured. In the journey of the PIB, which went on for well over 10, 12 years, initially the proposal was 10% equity for communities. And then the next iteration of the PIB, or perhaps the first iteration from the initial policy reform suggestions, the next iteration of the PIB now changed that from 10% equity to 10% of profits. Then the second version of the PIB changed that from 10% of profits to 5% of profits. Then the final version of the PIB, which was now passed into the Petroleum Industry Act, changed that further from 5% of profits to 3% of the operational, or is it operating expenses of the companies. So that's a huge conversation that we haven't really engaged. But the important thing, for now at least, as they say, half bread is better than none, right? So there's a 3% of operational expenses fund for the communities. The first time that the law will be reserving something directly for the communities. However, the PIA gives with one hand a crumb of bread, not even a half loaf of bread, a crumb of bread, it gives with one hand, and then it takes it back with another hand. And what I mean is this, it says that if there is vandalization or damage caused by a third party, then the community will not get that. In fact, the damage will be repaired with funds from the host community, what should have been accruing to the host community, which means that let's look at a hypothetical scenario that a particular host community is supposed to be getting under the Host Community Trust Fund 1 billion naira, over a period of 1 year, which means that in 5 years, it will be getting 5 billion naira. Now there's a major damage. For example, the 2021 Santa Barbara blowout, which drew global attention. So big, so huge was it. Now let's say that it will cost 10 billion naira to fix that. With all the inflation and the corruption and everything we know happen in the petroleum sector in Nigeria, where what should ordinarily cost 100 million naira may cost 5 billion naira. So let's say it will take 10 billion to fix it. That would mean that in principle, for the next 10 years, that host community will not get anything. How does Nigeria make such a law in 2021?
So can we say that there's a corporate capture of our environmental policies?
There's absolutely corporate capture of our communities, and indeed of Nigeria. Because in the first place, using the PIA as a benchmark, as I mentioned, and we all know that the PIB discussion went on for over 12 years. In all that period, the dialogue was between government and industries. The communities were never part of that dialogue.
Yes.
Again, another scandal. And another evidence of what I said earlier about the historical political roots of our industry, of the petroleum industry, and even of our institutions of government. The fact that the underlying motive or interest is always the economic or financial interest of those who are making, that's the individuals or interests that are making the laws and those who are operating in the industry. Never the environment, never the communities.
We'll go on a short break, and when we return, we will hear how these policies can better help communities. Stay tuned.
The manner in which the company has been operating in the Niger Delta in most communities, as if they are lords and nobody could speak to them, as if they are above the law, nobody could tell them what to do, which is very, very sad.
Our periwinkle have gone away. Our crayfish have gone away. Our crab has gone away. Our shellfishes are like ostra, all those fishes have gone away.
The Niger Delta, for example, has been so abused by oil and gas extraction for the past almost 70 years. Right from when the first commercially viable oil well was drilled in 1956, and even before then, there were a lot of oil wells and prospecting going on in the region. But from 1956, that marked a turning point where a once beautiful environment became highly damaged by irresponsible activities.
Oil has divided all the communities, even family, ordinary family.
Before we went on the break, we were talking about the PIA and communities. And we are aware that most community people are not fully educated about what the PIA is. Can we talk about how environmental education and awareness can be given to communities?
Okay, environmental awareness. Communities, of course, but beyond just communities. Because the essence of the awareness is to ensure that all parties, wherever you are, you contribute towards ensuring environmental sustainability. So at the bottom of it, for want of a better phrase, the communities, right? Very important. Constant engagement. But who is going to be doing that engagement? Are you going to be engaging communities if you don't think that it's in your interests? Often hidden agenda interests, for communities to be aware. So it's not likely that governments, whether federal or state, I'm not aware that federal or state governments, including regulators, apart from the occasional sensitization workshop and so on, are doing any proper education and awareness, environmental education and awareness campaign plugged to the communities. No, which means it still falls back on civil society. Civil society, by definition, is very limited because of lack of resources. So they too probably won't be able to cover the field, but it's important to try and up the game and do more intensive environmental awareness campaigns at the grassroots level, at the community level. But it's very important to say that the engagement should not be limited to communities. Communities, very important, most important. But beyond communities, there has to be engagement with all other sectors, including the judicial sector, which has been missed out so far. There has to be sensitization of our judges, our court systems, for them to appreciate the importance of environmental sustainability and the gravity of the problem that we're facing. It's an existential problem. I don't know how I would be a judge, all right? And then there's a case of a big spill before me. And I will not, even if the lawyers don't ask, the judge should be able to say, this thing you are alleging, let us go to the site. make an arrangement, let us go to the site, I want to see it myself. There are thousands of environmental pollution cases. I'm not aware of a single time, maybe there are and I'm just not aware. I'm not aware of a single time when a judge has been so moved by the visuals before him or her that he directs that a visit to what lawyers call the locus in quo, that's the site of the incident, be arranged.
Okay, so recently the Bayelsa State Oil and Environmental Report, an Environment Commission released a report similar to what the UNEP report talked about Ogoni. As a lawyer, what are your recommendations from that report?
I have a single bullet recommendation, which is the Bayelsa State government, which means the governor of Bayelsa State should implement the report. We can speak grammar for another one day, all right? But at the end of the day, implement the reports. That panel, very eminent team of experts with fantastic work, it's time for action. There's a lot more that we can say about what should be done, what should not be done. The report is innovative in the sense that, unlike the UNEP report, that does not have a health component, the report has a health component to it. So it's more, in that sense, it's even wider in coverage. There's a lot more assessment to be done, no doubt, but that report is sufficient basis. If we are serious, and by we, I'm not talking about the oil companies, because they are the primary perpetrators. I'm not even talking about the federal government, because going back to that historical, structural issue of the purpose of the Nigerian state, which is to extract, it's not to develop the people, all right? It's not to protect the environment. It would be naive to be expecting the Nigerian state, unless you compel them. You have to be the one to compel them.
So lastly, how can environmental justice and equity be prioritized in our policy making?
Until we do those things that will ensure a repurposing of Nigeria, I think it will be a pipe dream. But that's not to say we shouldn't have ambition, we shouldn't make attempts. How can environmental justice and equity be prioritized? It can only be prioritized by self-assertion. Because people have been crying, lamenting, preaching. Then when you get to the rostrum, you talk tough and all of that, all right? It can only happen through human instrumentality, which means that if federal government is not prioritizing it, state governments, the affected state governments should prioritize. If they are not, as the evidence shows that various governments are not prioritizing environmental justice, then the people, because they're the ones bearing the brunt. It used to be, if you remember, that for land cases and for other cases, people in the communities will contribute money to pay lawyers or to take other steps. Not that they had so much money, but they realized, that whatever interest they were trying to protect, they got it from their ancestors and they owe it to preserve it for their descendants. So they did everything they could. Women would sell their wrappers and contribute. So how is it that suddenly communities are never able, even communities with traditional rulers who have batteries of degrees, PhDs, have been X this and X that, and communities continue to play victim? So environmental justice can only be prioritized when those who are bearing the brunt decide to get up and assert themselves.
You've been listening to Barrister Iniruo Wills, and we've come to the end of today's episode. You would agree with me that strengthening regulations and empowering communities with the right information is key to becoming better protectors of the environment. Thank you so much for availing us your time. We hope that when we come to you some other time for more information, you'll grant us your time.
If I have more information.
Please join us on our next episode as we continue to discuss other environmental issues. Remember to follow us on our social media handle on Echo HomeF and visit our website www.homef.org. I remain your host, Kome Ojomo.